As every business person knows, the employees of the business are one of the most critical elements of the business. It happens from time to time that particular employees are no longer a fit for the company. Their time in that company has run its course, and it becomes time to terminate the employment of those employees. Any employer has the right to terminate the employment of any employee any time the employer wants, as long as one of two conditions is met. First of all, termination for cause. That's the situation where the employer has the right to terminate the employee based upon something the employee has done that's wrong. Summary cause is a single incident, such as theft, dishonesty, breach of trust, gross insubordination. A single incident of any of these entitles the employer to terminate the employee and to give the employee no notice, no severance, and no payment at all. Performance-related cause involves the employee not living up to the expectations of the employer in terms of the employee's performance. The law requires the employer to provide the employee with an opportunity to understand what it is they're not doing right, give the employee the tools to improve their performance, and also to set guidelines and deadlines for the improvement of that performance to the level that's required. And that takes time. It also requires documentation from the employer's point of view to give the employee the opportunity to improve. I don't recommend to most of my clients that they terminate employees based upon cause. Very often that requires an enormous amount of documentation and ultimately may lead to a lawsuit with the departed employee. There is a far better way to do the termination of an employee that serves both the interests of the employer and the employee. And that's terminating the employee for reasons other than cause. The employer can do so as long as the employer gives proper notice. Notice means notice to find another job. The three bases to determine the proper notice period, or what we'll call reasonable notice, are as follows. Number one, if there's a contract. In some cases, employment contracts contain a provision that says, on termination, the severance period that you'll be entitled to, if you're not at fault, is whatever you as the employer and the employee agree upon. Very often, though, employment contracts do not contain a provision for termination. Most employers don't want at the time of the marriage, which is the employment contract, to talk about the divorce. So, if there's not a provision of an employment contract that talks about the notice period, how then to determine what the notice period is? There are two bases to do that. The first basis is pursuant to the Employment Standards Act. Now, that Employment Standards Act is a minimum standard and applies only to entry-level employees. So, clerical, menial, non-supervisory employees are governed by the minimum standards of the Employment Standards Act. Under the Employment Standards Act, the proper notice period is effectively 1 week per year of service, to a maximum of 8 weeks. The second one, which is the more likely and more usual way of determining notice periods, particularly for management staff, is pursuant to the common law. And the common law of the province of British Columbia says in general terms that a supervisory employee should be entitled to somewhere between 2 months at the low end and 24 months at the upper end. Because 24 months is the maximum that the courts say any employee needs to find another job. So a court takes into account the following factors: the age of the employee, the position of the employee, the education that that employee has. The court also looks very seriously at the length of service. How long has that employee been with the employer? And the salary level. In addition, the court takes into account the responsibility that that employee has. In other words, how many other employees report to that employee? Importantly, what authority does that employee have? Do they report to the president? Do they report to the general manager? Do they report to someone lower in the chain? As a rough rule of thumb, for our purposes, a middle manager will get 1 month per year of service. A senior manager will get more than 1 month per year of service. And, not surprisingly, a junior manager will get less than 1 month per year of service. So let's assume that the proper notice period for a particular employee is 10 months. That 10 months severance can be given to an employee in a number of ways. The first way is by working notice. The second is by way of a lump sum. And the third is by way of a process called salary continuance. The employer can say to the employee, you have to stay on for the 10 months and work, and we're giving you working notice. I don't recommend that to my employer clients, because what you have then is an employee who's not happy, who has access to all of the confidential information, is not likely to be productive, and will diminish the working morale in the company for the 10 months that they're there. The second way, of course, is a lump sum payment. You give that employee a check for 10 months, less the statutory deductions. That's a windfall for the employee. They get 10 months in their pocket. They can put some of that into an RRSP. That serves the interest of the employee, but not the interest of the employer. The company can give that same 10-month notice period by way of a month-by-month payment. The employee doesn't show up to work, but gets paid in the normal course, and that's why it's called salary continuance. There is a legal principle called mitigation of damages. That principle involves a person who has had their contract, in this case an employment contract, terminated. They've suffered damages, but they have a legal obligation to mitigate or minimize that damage, and in the employment context, that means they have to find another job. They're not obliged to take any job that comes their way. It has to be a comparable job that they're well suited for and pays them approximately the same as their old job. And as soon as they find another job, mitigate their damages, the obligation of the employer comes to an end. The preferred way to go is for the employer to terminate the employee and give them a month-by-month salary continuance package. And then to add to that package an incentive bonus. That's an incentive to the employee to find another job sooner rather than later. Let's take an example of an employee for whom the proper notice period is 10 months. For the purposes of this presentation, let's say that employee finds an alternative position that's reasonable and commensurate with their former employment after 3 months. The incentive bonus, which is part of the package, says you will get 50% of the remaining period of your notice period as a lump sum payment, as an incentive to find another job. So the employer ends up paying the employee 3 months on the month by month and 3.5 months by way of the incentive bonus, for a total of 6.5 months. That's a very good deal for the employer, because the employer was on the hook for 10. So that same employee with a 10-month notice period gets paid 3 months by the old employer and then 7 months by the new employer in that 10-month period. As well, that employee gets 3.5 months as the incentive bonus at the end of the first 3 months. The employee ends up in a 10-month period with a 13.5-month severance package. That serves the interest of the employee as well. The goal is to ensure that the termination of the employee is done in a compassionate way that also serves the best interest of the employer, and at the end of the day, avoids the cost and the time of litigation. If you are in the situation where there is to be a termination of the employment of one of your employees, give us a call. We can help you. We can help you effect that termination in the way that serves your interests best.